This is a basic criminal procedure review series, and this is part 1 of 7 episodes provided to you in this series. My name is Tom Higgins. I work at Illinois Central College as a professor of law enforcement, criminal justice, 911, and legal studies. My educational background, I have a degree in police science in 1985, criminal justice in 1987, a law degree and law license in 1990. I started out on the law enforcement career path, ended up going to law school, worked for the Illinois Attorney General in criminal appeals and on death penalty cases when we had the death penalty. I moved to private practice where I had police officers and police unions among my clients. And I served as a municipal hearing officer in Central Illinois for over 20 years, taking testimony from police officers, many of whom over the years were my students or former students. Some of you may have had me as a student, fewer of you had me as a hearing officer or lawyer, and all of my contemporaries are otherwise now long retired. But I'm not retired. I have no intention at this moment of retiring, and I'm no less committed to the topics I'm going to talk about in this series than I was over 40 years ago when I entered this field. I'm intent on giving you something to think about in hopes that you stay safe, you keep others safe, you uphold and follow the law, and by doing so, you enjoy the type of career you intended on the day you raised your right hand and took your oath and swore to uphold and abide by the things I will discuss in the 7 parts of this procedure review series. It's a little bit about me and my goal and intent. I will say, and I'll probably repeat this throughout the series, if I can answer any questions or be of assistance regarding, things within or outside of this course, reach out, and I'll be happy to help. The purpose of this series is that it's intended to be a basic review and reminder of the high points of criminal procedure. Now, I've created podcasts for my law enforcement, criminal justice, 911, and legal studies students for courses at Illinois Central College for some time now, and the students appreciate these resources because the information is accessible from any device at any time, and that's the case with this information. The idea for that effort on my part is that it's supportive of learning when you're reviewing the high points of the law in a way you hope the recipient will grasp and recall when needed. You can always pause this audio when it's difficult to concentrate because of work, family, whatever's going on. You can always go back and listen, re-listen, and when needed, you can go back much later because you'll have the link. And otherwise, you can gain and retain and review this information, and you can do it without making a special trip to work, the police training center, or another location to sit in a chair for several hours. This has been true for our students, and I think this is going to be true for you. You don't have to be tied to a screen for this information. You can listen on the way to work, in your car, in your squad car, at home, at the gym, or anywhere else. And I suggest that you do that and you find what works best for you as far as your ability to retain this type of information, because I think you're going to find it more and more often being offered in this way. Now, to be clear, although the format is convenient, the topics are very serious. You have a duty to stay informed and current about any changes or developments in procedural law, just as you have the duty to stay informed and current about changes or developments in statutes and ordinances that you're expected to enforce every day. I offer this information out of a sincere desire to never see or hear about you or anyone else ending up in a pickle out of ignorance or lack of recall of the very basic procedural expectations we will cover in this series. This first episode is intended to review criminal law versus criminal procedure. You can look up the elements of a crime and the requirements of a statute or ordinance, and you should regularly, even though you may be certain you know what the statute or ordinance says. While the general elements of assault or battery are likely to stay the same, the wording of statutes, definitions, penalties, those change. Most of you know staying consistent with your use of the statutory language as you incorporate facts of an incident into your report is key to you having fewer opportunities to get burned on the witness stand under cross-examination. Experienced officers know when you don't either stick to the language of a statute or ordinance, or worse, you completely miss a change in the language of a particular statute or ordinance, you can expect to be grilled, embarrassed, taken to task, right? You don't want to be there. The awesome thing is that you always have this type of information at your fingertips, or you should. You should have the statutes available to you. Now, you don't have to carry a big old bag to your squad car anymore that contains all of the criminal statutes. You have them available at your fingertips. So review the law regularly. Maybe every time you go to write the report, pull it up. Pull up that statute or ordinance and just make sure. Be intentional about connecting the facts of the call or incident you're writing a report about to the elements of the statute or ordinance you believe was violated. And this is a criminal law, right? You know this. I'm not trying to suggest you don't, but I will suggest that we sometimes lose focus that criminal law and criminal procedure are two distinct things. Criminal law is the what. What citizens are expected to do or refrain from doing, what you are expected to enforce or uphold. Criminal procedure, on the other hand, is the how. How we, as law enforcement professionals, approach, address, investigate, process, prosecute, and punish citizens for violating the criminal law. Where criminal law is statutory, created by the legislature, criminal law, or procedure, comes largely from case law. Case law generated through the United States Supreme Court that evolves through new court decisions daily. It's applied to new fact scenarios. And while you may find codes of criminal procedure at the state and federal level, case law is going to drive where you need to be and where you need to stay competent. If we think of the geography and courtrooms in a typical courthouse in the same sense, most cases of one type or another can be divided into civil or criminal. Some of you work in smaller counties and there may only be one courtroom or possibly one large and one small courtroom and one judge responsible for hearing every type of case filed in that courthouse. In more populated counties, you may see several courtrooms and a single judge assigned to hear specific types of cases, only misdemeanors, only felonies, only divorce, family law cases. It's reasonable to expect that more courtroom time is spent, whether it's in this smaller or larger county, on criminal, misdemeanor, or felony cases. As those cases move on to appeals, we can expect criminal cases to take up the largest portion of the dockets of the 5 Illinois appellate courts. And most issues raised in those appeals revolve around issues of police expectations, citizens' expectations, and the law of procedure. Rarely, or less so, is it about whether the facts of the case indicated that a particular act had occurred. It's more about how that act was discovered, the arrest occurred, the investigation occurred, the trial presentation of evidence occurred, something related to procedure. So you need to know to use resources from your department, police training, MTU opportunities, all sorts of other free resources. And you know most of those. If you haven't looked at things like Police One is a website you can register for, where you can get updates of a lot of different things. And there's several of those resources. I'm sure you're aware of those. But, you know, as much as all the other social media is good, you should probably devote some time to some of these law enforcement professional related materials. Legit law enforcement related professional materials and resources. There's some basic tenets of procedure you must know, you must recall, respect, and follow. And you know, when the call comes, you don't have the time to review these basics as the situation unfolds. These things need to be in your DNA, second nature. This first episode will review the distinctions between criminal law and criminal procedure and set the tone for what you can expect in the more topic-focused episodes. The next episodes are going to break down in episode 2, stop basics, in episode 3, frisk, vehicle stops, protective sweeps, and we'll cover arrest and Miranda. In episode 4, we're going to cover the exclusionary rule. In episode 5, warrants, both arrest and search. Episode 6, search without a warrant. And then in episode 7, we're going to cover use of force. Now, I've already covered some of the differences between criminal law and criminal procedure, but I'll go a little further. I provided some materials for you, pretty short, basic, something that you can save, download, print, and have available. Within that is a chart that expands further on the differences of criminal law versus criminal procedure. Criminal law defines the rights and obligations of individuals in society. Common issues in criminal law are the elements of specific crimes or offenses and the elements of various criminal defenses. Criminal procedure concerns the enforcement of individuals' rights during the criminal process. I want to say that again. Criminal procedure concerns the enforcement of individuals' rights during the criminal process. I think when we get askew, when we end up in situations we don't want to be in, or when we see those situations unfold because, we don't ever want to be that person that was on the video or whatever. you have to have at least a thought in the back of your mind that the person involved, the law enforcement professional, the law enforcement officer, and I use the term professional because I think we've gotten away from that expectation. And I think you have to look at it that way. You have to look at this as your calling, as your duty. You take an oath. You have to have higher expectations for you and the people you work with because it keeps us all out of trouble. In any event, I think you can agree that in many of those circumstances, it's pretty clear that the officer under scrutiny has possibly lost sight of these laws, these cases, these rules, these expectations, the Constitution. Are intended to protect the rights of individuals and not us. Examples of procedural issues revolve around an individual's constitutional right and expectations of law enforcement during investigations, arrest, filing of charges, trial, and all the way through appeal. Now there's a chart in the materials that I provided, and it kind of breaks it down even simpler. So criminal law is concerned with the rights and obligations of individuals in society. Criminal procedure is concerned with individuals' rights during the criminal process. Criminal law is concerned with whether a defendant committed a crime, which crime the defendant did commit, and does the defendant have a defense? Criminal procedure is concerned with, did the government act legally when investigating, arresting, and prosecuting the defendant? At its most basic level, you should think of these differences in this way. Criminal law is the what? In regard to the sworn duties you've taken to uphold and enforce the law. It defines the offenses for which you might make an arrest. Criminal procedure is the how in regard to your sworn duties to uphold and enforce the law. It defines the process or procedure that you must follow through every interaction with a person that may involve in any way a violation of criminal law or lead to an arrest. Now later in episode 4, we're going to take a look at the exclusionary rule, and the exclusionary rule comes to us through the landmark United States Supreme Court case of Mapp versus Ohio. Most of you probably heard of that case. If you don't recall it by the name, you definitely recall the exclusionary rule. You definitely have learned, been trained, and hopefully have as part of your foundation some of the principles of this case, if not all of them. It's a good case to help us differentiate criminal law and criminal procedure, and we're, as I said, going to revisit it when we get to the fourth part of this series in the exclusionary rule. Mapp was decided on June the 20th of 1961. So it's just a little bit older than me. The U.S. Supreme Court ruled that under the Fourth Amendment and the 14th Amendment, illegally seized evidence could not be used in a state criminal trial. This decision changed state law enforcement procedures throughout the country. The case began in May of 1957 when the Cleveland police entered the home of Miss Mapp. Dalry Mapp was her name. They entered the home looking for a person who was wanted for questioning in a recent bombing, and they were also seeking illegal gambling paraphernalia. After a thorough search, the police found neither the person nor the gambling materials. They did find obscene material, and Miss Mapp denied owning that material. Now remember, this is 1961, so there weren't gambling machines in every bar and restaurant, and you couldn't go to your phone or whatever device and find what probably is way beyond the comprehension of the court or anyone else back in 1957 of what was obscene. But possession of obscene materials was illegal according to state law, and Mapp was arrested. And in the fall of 1958, she was tried, convicted, and sentenced to 1 to 7 years in the state penitentiary. There was no search warrant produced at the trial, and there was no failure to produce one accounted for. Mapp's lawyer appealed to the Ohio Supreme Court on the basis that the Ohio's Obscenity Law violated the privacy rights of citizens, and only secondarily that the conduct of the police in obtaining the evidence was unconstitutional. The Ohio Supreme Court affirmed the conviction, and despite the absence of a search warrant, they also ruled that the illegally seized evidence could be entered in the criminal trial, or that illegally seized evidence could be entered in a criminal trial. It was sort of, at the state level, the wild, wild west. All the things that you have as an expectation today that you know is what the law requires, that didn't happen at the state level. It wasn't the expectation until Mapp. So Mapp's lawyer appeals to the United States Supreme Court, contending that Mapp's conviction violated her constitutional rights. The court asked the ACLU to submit a brief, and that was probably the more compelling arguments made in the case. But the ACLU lawyer essentially urged the Supreme Court to examine the constitutionality of the search and seizure, contending that since federal courts prohibited use of evidence obtained in this way, it was illegal for the FBI to do what the Cleveland police or any local or state level police might have been doing in those days. Because for the same reasons that the court applied then those same expectations to state and local police, the court ruled that, in overturning Mapp and her conviction, that evidence seized without a search warrant cannot be used in state criminal prosecutions under the Fourth Amendment of the Constitution, which protects against unreasonable searches and seizures, and the 14th Amendment, which extends that protection to state court or state jurisdictions. This decision, like many other decisions that we're going to talk about that came out of that time period, forever changed how local and state police agencies operated. It changed the expectations of citizens as well. But the point is that Mapp v. Ohio and several other landmark United States Supreme Court cases from that time period helped define procedural law. These cases defined the how of what you need to do for your job from the moment you are sent to a call or you encounter a circumstance, all the way through trial, conviction, sentencing, punishment, and appeal. Now we're going to touch on throughout this series the procedural expectations for the other players, the other people involved in the process after the police or along with the police. It's important for you to know as a law enforcement professional those steps and those expectations. But to be clear, our focus is going to be towards the procedural expectations for you, for police officers. If you want to find out more about Mapp, in the written materials I've linked a podcast regarding the case directly from the United States Supreme Court. You can also find the decision if you haven't read it, and you may have read it. It's it's not an easy read by any means, but the podcast or the audio is pretty interesting, and concise. So you might want to do that. It'll give you some background, and background's not a bad thing. That's it for this first session. Think about the differences. Think about your obligation and your duty to stay up on and consistent with your application of procedure as much as you have the duty to stay up on and know what the statutes and ordinances require or prohibit and the offenses that you're out there enforcing and protecting the public from. I appreciate everything you do. I hope that you enjoy the rest of this series, and if you have any questions, as I said before, if you need anything, reach out.